Hello and welcome to Daily News Simplified, an answer to what, why, and how of newspaper reading. Today we will discuss the articles displayed on the screen from the daily edition of the Hindu newspaper dated 10th May 2019. So let us start our discussion. Now, this article on page number 1 talks about the appointment of judges in the Supreme Court. And it talks about the full strength of the Supreme Court, that is 31 judges. Now, this is in news because recently the government had rejected or returned the advice of the collegium regarding the appointment of 2 new judges. However, the collegium has again asserted that the government cannot reject the suggestions which have been provided by the collegium. So, in this regard, this shall form a part of the preliminary examination syllabus under the topic Indian Polity. And in this article, we'll look at the strength of the judges in Supreme Court and what is the procedure of increasing the strength of the judges in Supreme Court. Secondly, the matter of appointment of Supreme Court judges has already been covered in a previous DNS video. So we will look at some important facts from that DNS video as well. So regarding the strength of judges in the Supreme Court or the number of judges in the Supreme Court, you should note that originally the constitution provided that the Supreme Court will have 8 judges only. And this includes 1 CJI or the Chief Justice of India and 7 other judges. So originally the constitution provided only for 8 judges in the Supreme Court. However, with need of time, the parliament increased the number of judges in the Supreme Court. So regarding the strength of Supreme Court, you should note that the parliament can increase the number of judges in the Supreme Court. So this power is with parliament and not with the president. So this should be noted here. Secondly, the parliament can increase the number of judges by an amendment to the constitution, which will be through a simple majority and will not be deemed as an amendment to the constitution under the article 368, which means that this is an amendment outside the scope of article 368. So the parliament has the power to increase the judges in the Supreme Court, and it can do so by a simple majority outside the scope of article 368, and this can be an important fact. And the latest increase in judges was done in the year 2008 by an amendment, and it increased the number of judges from 26 to 31. And these 31 judges include 1 Chief Justice of India and 30 other judges. So presently the strength of Supreme Court is 31. And presently there are 4 vacancies that are lying in this full strength of the Supreme Court. And that is why the collegium has recommended that the government should appoint 4 more judges. However, the government has returned the names of 2 judges. And on this return of the names of judges by the government to the collegium has once again said that the government is bound by the recommendations of the collegium. Now, the appointment of judges of the Supreme Court has been dealt with in the DNS of 12th January 2019. However, let us look at some of the points that were discussed in that video. Now, regarding the appointment of judges of the High Court and the Supreme Court, they are appointed by the President. However, the Constitution provides that the Chief Justice is appointed by the President after the consultation with such judges of the Supreme Court and High Court as he deems necessary. So according to the Constitution, the President cannot appoint anyone on his own, and he has to consult with the judges of the Supreme Court and High Court as he deems necessary. Regarding other judges other than the Chief Justice of India, they are appointed by the President after consultation with the Chief Justice and such other judges of the Supreme Court and the High Court as he deems necessary. So in this regard, the Constitution provides that the consultation with the Chief Justice is obligatory in case of appointment of judges other than the Chief Justice. However, the provisions have not been clearly identified in the Constitution or dealt with in the Constitution. And that is why this matter went to the court, and the court has provided various judgments regarding the appointments of judges in the Supreme Court. Now, the provision of consultation of the President with these judges of the Supreme Court has been a matter of controversy in the appointments of judges. And this matter went to the court. And in the first judge's case of 1982, the Supreme Court said that the consultation does not mean concurrence and it only means an exchange of views. So in short, the Supreme Court said that the executive will have a primacy in the appointments of judges, which means that the President can consult with the judges of the Supreme Court. However, he is not bound by that advice. However, in the second judge's case of 1993, the Supreme Court reversed its earlier ruling. And in this ruling, it said that the word consultation amounts to concurrence, which means that the advice which is provided by the Chief Justice of India is binding on the President in the matters of appointment of judges of Supreme Court. So the advice or the consultation with the Supreme Court is binding on the president, and this was provided in the second judge's case in the year 1993. Further, in the third judge's case of 1998, Supreme Court expanded the scope of the second judge's case result. And in this case, it provided that the consultation of the president with the Chief Justice does not necessarily mean the consultation with Chief Justice only. And it provided for consultation of plurality of judges. So in short, it laid down the principle of collegium system. So this judgment in the third judge's case provided for a collegium system, and it provided for a forum of Chief Justice of India and 4 other senior most judges of the Supreme. And this collegium will provide recommendations regarding the appointment of judges. So the second judge's case has provided that for the appointment of judges in Supreme Court, the consultation with the CGI which the president needs to do amounts to consultation to concurrence, which means that the government is bound by the advice which has been forwarded by the collegium. And this is the matter which has sprung up in the news article that we are discussing. To further get the details of the appointment of judges in the Supreme Court, you can go through the DNS of 12th January 2019. With this, let's move to the next article. This article on page number 14 reads that the Ministry of Corporate Affairs has recently notified the thresholds for filing class action lawsuit. So in this article, let us try to understand what is meant by class action lawsuit and what does the Indian law say about the class action lawsuits. So this will be a part of preliminary examination syllabus under the topic economic development. So regarding the class action lawsuit, you should note that it has been introduced in the section 245 of the Companies Act. So the law which deals with the class action lawsuit is the Company Act of 2013. And this provides for a redressal mechanism for small and the minority investors in a company. So it provides for redressal mechanism only for the small and the minority investors in a company. And when do the small and minority investors file a case against the company? So it provides that under this act, investors can file a case before the National Company Law Tribunal. And they can do so in case they feel that the management or the conduct of the affairs of the company are against the interest of the company or its shareholders. So where can the small investors and the minority investors file their case? So they can file their case in the National Company Law Tribunal or the NCLT. And in such cases, there are provisions for damages or compensation. So in such cases, it also provides the options of claiming damages or compensations or demand any other suitable action against the company or its directors. And this can be done in cases of fraud, unlawful or wrongful acts. Now the class action lawsuit is a well-established principle in most of the foreign countries, for example, the United States of America. And in these countries, the minority shareholders can claim compensation or damages if the company presents the false accounts to their investors in order to hide the losses and inflate the share prices. So in such cases of frauds, these countries provide for class action lawsuit. Now in India, this provision has been introduced after the famous Satyam scandal. And in this Satyam scandal, the Indian investors or the small investors were not able to claim compensation in spite of false accounts being presented by the Satyam company. And due to the Satyam scandal and the loss of the minority or the small investors, the government has introduced the class action lawsuit under the Companies Act of 2013 to benefit the shareholders. Now, what is the limit for defining who falls under the small or minority investors and who all can file a class action lawsuit? So the threshold for filing a class action lawsuit is that an application for class action can be filed by a member or members representing 5% of the total members of a company, or it can be done by 100 members of a company, whichever is less. So either those members which represent less than 5% or less than 100, whichever is less. So in case the 5% of the total membership comes out to be more than 100, only people less than 100 can apply for such class action lawsuit. So these are a few important points related to class action lawsuit, which can be important for us from preliminary examination point of view. With this, let's move to the next article. Now, this article on page number 18 talks about the barn owls which are being introduced in the island of Lakshadweep to contain the menace of increasing population of rats or the rodents. So, this will form part of the preliminary examination syllabus under the topic Environment and Ecology because it is a method of biocontrol. So, let us look at some facts that emerge out of this news article. Now, these barn owls are being introduced in the island of Lakshadweep to contain the menace of rat population, which is adversely impacting the coconut yield on the island of Lakshadweep. And these owls are being brought from Kerala, and these are known to be a natural enemy of the rats. And that is how the government aims at containing the increasing population of rat on the islands of Lakshadweep so that it does not adversely impact the coconut yield. Now, such introduction of species to contain the population of other increasing population species is known as a biocontrol method, and it involves introduction of such organisms or animals which are natural enemies of the invasive species. Now, natural enemies of rats can include cats, snakes, etc. However, in case of Lakshadweep, the rats or the rodents live on treetops, and they can move from one tree to another tree because the coconut plants are close enough. So, in such a scenario, the cats and snakes can become ineffective, and that is why the owls are being introduced. And these are known as natural rat hunters. Further, these are nocturnal in nature because they are active at night, and they have powerful auditory mechanism, which means that their listening power is very strong, and that is how the government aims at containing the population of rats. And why they have chosen the barn owls has also been discussed. Now, the biocontrol methods are also used to control pests as well as invasive plant species. So, you should be aware of the definition of biocontrol. With this, let's move to the next article. This article on page number 18 talks about a pesticide which has been banned in California and US. And it was known to be adversely affecting the brain development of the babies. So, this will be a part of preliminary examination syllabus under the topic Environment and Ecology. So, let us try to understand some facts related to this pesticide and also some facts related to the Stockholm Convention, which deals with the persistent organic pollutants. So, regarding the pesticide, you should note that California in US has banned this pesticide, and the name of this pesticide is chlorpyrifos. And its side effects include it harms the brain development of babies, and it is also a toxic air contaminant. However, you should note that it has not been banned under the Stockholm Convention, which is related to the persistent organic pollutants or the POPs. Now, after this, let's understand the key facts related to Stockholm Convention, and it can also be an important aspect for us from the preliminary examination point of view. So, regarding Stockholm Convention, you should note that it is a global treaty to protect humans' health and environment from persistent organic pollutants. Now, what are these persistent organic pollutants? So, the POPs are chemicals that remain intact in the environment for long periods, and they become widely distributed geographically, and they accumulate in the fatty tissue of living organisms and are toxic to human beings as well as wildlife. So, these persistent organic pollutants have a tendency of bioaccumulation by the way of accumulating into the fatty tissues of the living organisms. Further, regarding the financial mechanism, you should note that the Global Environment Facility is the designated financial mechanism for the Stockholm Convention. Besides this, the United Nations Industrial Development Organization is also responsible for supporting developing countries and countries with economies in transition to help the implementation of Stockholm Convention. And regarding India, it has also signed and ratified this convention. So, all these facts are important and can be important for us from the preliminary examination point of view. So, at the end of today's discussion, you will find a question related to this Stockholm Convention. With this, let's move to the next article. Now, this editorial on page number 8 talks about the issue of Afghanistan. And it has highlighted that there has been an increased violence by Taliban against the Afghanistan government. So, to curb the violence of Taliban against the Afghan government, the Afghanistan's Loya Jirga, which is a Grand Assembly, has pushed for ceasefire between the Afghanistan government and the Taliban. Further, we also know that the US and Taliban are negotiating for US withdrawal of troops from Afghanistan. And also the US is trying that the Taliban should agree for talks with Afghanistan government and stop violence against the government. However, all these demands of Loya Jirga as well as the United States of America have been rejected by Taliban. So to stop the violence of Taliban against the Afghanistan government, this editorial argues that the US should further put pressure on Taliban to accept the ceasefire thing. So this is a news in transition. However, what is important for us is to learn about the term Loya Jirga. And this will be a part of important international events under the preliminary examination syllabus. Now the Loya Jirga, which has called for a ceasefire between Taliban and the Afghanistan government, is basically a grand assembly comprising of elders, tribal chiefs and religious leaders in Afghanistan. Now this is an old assembly which has been taking place in Afghanistan and it is favored by the Pushtun people of Afghanistan. However, it is also supported by some other groups in the Pakistan-Afghanistan region. And as far as history is concerned, the Loya Jirgas have been reportedly organized since the Kushan Empire under the Kanishka. Further, they are similar to the Sabhas in the ancient India. So in this line, the Loya Jirga has called for a peace or ceasefire agreement between the Taliban and the Afghanistan government. So a simple question can appear in the exam. For example, Loya Jirga sometimes appears in the news is, so here as we have learned, it is an assembly of elders and tribals in the Afghanistan. So you should be aware about the term Loya Jirga. With this, let's move to the next article. This article on page number 8 talks about the recent charges of sexual harassment against the Chief Justice of India. Now, normally the articles which have appeared in the newspaper have highlighted that the procedure which was followed by the Supreme Court in handling the charges against the Chief Justice of India were illegal or not proper. And the critics of this procedure have highlighted that the principles of natural justice were not followed in handling this case. This was particularly because the Chief Justice of India himself placed along with other two judges in hearing a case against himself. However, this article talks about the other point of view. And in this line, it argues that the procedure which was followed was neither illegal nor arbitrary, and it was based on the report of Committee on In-House Procedures, which was created in a meeting of full court of Supreme Court, which was held in the year 1990. So this will form a part of the General Studies paper 2 under the topic Polity or Constitution. So in this article, let us try to understand what is this report of Committee on In-House Procedure and what does it talk about. Also, what is the procedure that is to be followed in cases of sexual harassment charges against the Chief Justice of India. And finally, we will look at the views of the author as he has highlighted in support of the procedure which was followed in the present case. Now, this committee was constituted in the year 1990, and the report of this committee highlighted an in-house procedure that was to be followed for taking suitable remedial action against judges in case of any allegations against them, including conduct and behavior of judges outside the court premises. So this committee basically dealt with creating an in-house procedure which would be followed in cases of conduct or behavior of judges outside the premises, outside the court premises. So this report of the committee highlighted that any allegations against any High Court judge, Chief Justice of the High Court or Judge of a Supreme Court shall be examined by his or her peers and not by any outside agency. And this was done in order to maintain the independence of the judiciary. So basically, this committee provided for an in-house procedure which was to be followed, and in that case, any cases against the judges of High Court or Supreme Court shall be examined by his or her peers and not by any outside agency. However, this report did not provide any procedure that was to be followed in cases of allegations against the Chief Justice of India. So normally, the procedure which was applicable to a judge of Supreme Court shall also be applied on the Chief Justice of India as well. So in this regard, let us look at the procedure that is to be followed in cases against Chief Justice of India. Now, as the report of Committee on In-House Procedure did not provide for a separate procedure that was to be followed for Chief Justice of India, so in such cases, the procedure which is followed for the judges of Supreme Court will be followed in the case of CJI as well. And in all these cases, a 3-member committee shall be constituted. And this will be comprising of Supreme Court judges, and this will hold an inquiry into the allegations. Now, regarding the nature of this committee, you should note that it will be of the nature of a fact-finding inquiry committee and it will not be of judicial nature. And in such fact-finding inquiry, the judges concerned or the judges against whom allegations have been made will be entitled to appear and have their say. And this committee will not be of the nature of judicial inquiry. This is because no cross-examination of witnesses is allowed and no representation by the lawyers is allowed. Further, the committee has been empowered to devise their own rules and procedures which are consistent with the principles of natural justice. So, based on the inquiry, the committee can file three kinds of reports. The first can be there is no substance in the allegations filed by the complainant. The second report can be there is sufficient substance in the allegation of misconduct, and such substance is so serious as to initiate proceedings for the removal of judges. It is for the parliament to take the decision regarding the removal of judges. The third kind of report can be that there is substance in the allegations. However, the misconduct is not of a serious nature so as to initiate the removal of proceedings. So either this committee can reject the allegations of the complainant, or if it finds sufficient substance in the allegations, it can recommend for the initiation of proceedings for removal of judges. Further, it can also provide that although the allegations have substance, however, these are not of grave nature or serious nature and they do not require initiation of removal proceedings. So after understanding the procedure for handling cases against the Chief Justice of India, let us look at the views of the author, and in which he has highlighted that the procedure that was followed in the inquiry against the Chief Justice of India was neither illegal nor arbitrary. Now, regarding the procedure that was followed, the author has said that there was no violation of any legal procedure as available in cases of allegations of misconduct against the judges of Supreme Court, including the Chief Justice of India. In this regard, he has highlighted that the complainant in this case did appear before the committee 3 times. However, she asked for permission to be represented by a lawyer and was denied as per the rules of procedure that have been provided in such in-house committees. Now, once she was denied the representation by a lawyer as per the rules of the procedure, she herself decided to stay away from the remaining procedure at her own discretion. Further highlighting that the principles of natural justice were followed in this case, the author says that there were 2 women judges to hear the version of complaint of the complainant, and the 3-member committee comprised of Justice S.A. Bobde, Justice Indra Banerjee and Justice Indu Malhotra, which means that out of the 3 people in the committee, 2 were women judges. And the inquiry report which was submitted by this committee did not find the allegations against the Chief Justice of India to be true. Further, the copy of this report was not made publicly available, and this was in accordance with the law which has been laid down in the Indra Singh versus the Supreme Court of India in 2003. Further, this judgment provided that the report of the committee, which is constituted as a part of in-house procedure, was confidential and discreet and could not be made public. So even not making a report public is legal as it has been provided in the Indra Singh versus Supreme Court of India in the 2003 judgment. So in denying the inquiry report, no laws or procedures were violated. So in this regard, the author has concluded that any allegation of violation of principles of natural justice or deviation from adhering any law or legal procedure does not hold ground, as the in-house committee followed every procedure which has been laid down by the Supreme Court itself. So in his views, the author has highlighted that the legal procedure that was followed in the complaint against the CJI was according to the precedents and the various judgments of the Supreme Court of India. And further, no principles of natural justice were violated, and also the procedure was legal and was not arbitrary at all. Now after this, let us take up these practice questions, and the answer for these questions will be displayed after 5 seconds. Now the first question reads, the number of puisne judges in the Supreme Court can be increased by. And by puisne judges, we mean that the judges other than the Chief Justice of India. So the options provided are A. President of India, second, Parliament by the amendment of Constitution under Article 368, third is Chief Justice of Supreme Court, and fourth is Parliament by amending the Constitution by simple majority. So as we have learned, the correct answer is D. The second question reads, with reference to the Stockholm Convention, consider the following statements. The first statement reads, it deals with the phasing out of persistent organic pollutants, which is correct. The second statement reads, India has not ratified this treaty. This is wrong because India has ratified and signed this convention. So the correct answer is A, that is one only. Further, you should try this question. So this question reads, consider the following regarding the appointment of Supreme Court judges. The first statement reads, the judges of Supreme Court are appointed by the President, which is a correct statement. The second statement reads, executive has the primacy in appointment of judges, which is incorrect because the judiciary has the primacy in the appointment of judges as of now. And this is particularly because of the third judge's case, which provides for a collegium system, and by the doctrine of consultation to concurrence, as was provided in the second judge's case. So the correct answer is A, that is one only. With this, we have come to the end of today's discussion. Now let's move on to the question for the day.